We have a call coming in. Rochelle, I believe it is, from Okaloosa County. Rochelle, go ahead with your question, please, ma'am.
My question is, I am getting older, and I need to know if I should have just a will or a trust or a living trust so that my son can get what I have.
Okay. Stan, you want to take a stab at that
I
question?
will.
Yeah.
Yes. How old is your son?
My son is 31.
Does he have any disabilities of any kind?
No.
Have any special needs that need to be addressed?
No.
Okay. Are you married?
How I can give, if something happens to me, how I can just like hand him off what I've got.
Are you married?
No.
Okay. All right. So we've got a will trust issue here, basically. Okay. Now, your son, is he independent? Is he on his own? He's got a job or his own responsibility with his family? Or is it something where you and your son are the only real parties that are connected in what we're talking about?
Him everything, and you know, I don't know if I should make him executor and the beneficiary. I got a question about that.
A lot of questions, and let me put it this way. In order to adequately cover those issues in a will, you need to speak with an attorney who does elder law work, or you need to speak with an attorney who is competent to put together a will package with probably health surrogate rules and maybe even a power of attorney that might be necessary regarding your assets. So I do that kind of work in addition to doing divorce work. I'm also a criminal defense attorney. And sometimes the criminal defense attorney for a domestic battery leads into a divorce case. I'm just using that as an example to show you. But what you're talking about now is writing a will that would allow for your assets and your liabilities to be addressed and for allowing your son apparently to receive the benefit of all of that. And so I would suggest that you make an appointment with an attorney who does will work or does elder law work to make a plan in that direction and possibly consider either a power of attorney use or something that we also call, that's called a ladybird deed, if it's property transaction that you want to try and avoid to get, avoid the probate issues. There are things out there like a ladybird deed, for example, that can help you with that. That goes beyond the scope a little bit of where we're at right now, so my suggestion would be you need to call a lawyer, consult with a lawyer that does wills work or elder law work for future planning for those needs that your son has.
Let me jump in on that also, Stan.
Sure.
Rochelle, some of the reasoning behind having to do that is that you may forfeit benefits that you are already receiving if you're getting any type of special Medicare or Medicaid benefits, and you don't want to forfeit those, number one. You know, if you are doing some estate planning and you transfer those assets prematurely, that can affect your eligibility for certain benefits that you currently are receiving. Number two is, you know, there's a lot that goes on into doing a will, whether it's a trust or a living trust, and some of that's dependent upon the valuation of your estate. Some individuals say, hey man, I just want to give somebody my home and 10 acres of land and everything that I've got, which is, you know, sentimental to me, that came from my parents or my aunt or whatever. And you can do all those things in a simple deed, and you can do all those things in a simple will that handles all the things besides real estate or real property, okay? Now, it gets more complex, and that's what Stan was alluding to. You need to seek out an attorney who specializes in this, because we don't want to have you answer these questions over air about your current situation. You can sit down with an attorney in their office and have confidentiality in the privateness of their own office and explain these things. And he or she's gonna ask you questions that maybe you didn't think of, you know, and so you have an opportunity to dwell on those and to think about those. And then he will formulate whether it can be accomplished in a simple will. Sometimes you can give someone a life estate and still retain the possession of the property and the enjoyment of the property. Or sometimes you can just keep the property altogether, and upon your passing, certain language can be added to a deed that then automatically transfers that property outside of probate. A lot of times you may have a car and that attorney that you're going to deal with can address those situations. But typically speaking, if it's a simple situation with not a complex financial accounts or that's going to trigger certain statutes either from the IRS, you typically can do a lot of that stuff with a will and still retain possession of all of your assets upon your death. So thank you for that question.